is all of our public market data is openly available and free, where risk parameters are transparent.
On November 7, 2022, Sam Bankman-Fried posted that FTX was fine and that its assets were fine. 4 days later, the exchange entered bankruptcy, and customers no longer had ordinary access to the money their screens said they held. A jury later convicted Bankman-Fried on 7 fraud and conspiracy counts, and on June 12, 2026, the United States Court of Appeals for the Second Circuit affirmed that judgment after reviewing his appeal. The question is not simply how a crypto company collapsed, but how an exchange that publicly described safeguards for customer assets became unable to return them. Before the failure, FTX presented itself in Congress as a large, sophisticated global exchange. Bankman-Fried told lawmakers that FTX had invested in risk controls, customer checks, monitoring, and transparency across the exchange he was describing. That presentation mattered because the product being sold was not only access to volatile assets, it was confidence that the institution behind the trading screen knew how to protect the system. In written Senate testimony, Bankman-Fried described 5 investor protection principles for a digital asset platform. They included enough liquid resources to return a customer's assets on request, secure custody, and ledgering designed to prevent misuse or misallocation. The same testimony said FTX used an in-house custody system with hot and cold wallets, multi-signature controls, and procedures intended to protect private keys. Those were representations, not independent proof, but they define the promise precisely. A number on a screen should correspond to assets that can actually be returned. The Commodity Futures Trading Commission later alleged that Alameda Research operated under rules ordinary customers did not receive. Its complaint described an essentially unlimited line of credit and an exemption from parts of FTX's automated liquidation process. The complaint also said some customer fiat deposits were routed into bank accounts controlled by Alameda and recorded through an internal account called Fiat at FTX, while the customers were not told that Alameda controlled the bank accounts. These are attributed civil allegations, but they identify a concrete mechanism behind the public promise.
On FTX, all of our users have full access to the platform. They have full access to the same sets of tools that institutions do.
That changes the shape of the story. This was not merely a separate hedge fund making bad trades and then asking an exchange for help. According to the regulator's filing, the exchange's own credit rules, deposit route, and internal accounting connected customer money to Alameda's access. The first reversal is therefore a custody failure. Customers believed they held a withdrawable claim, while the institution had created a privileged path around that claim inside its own operating relationship. In early November 2022, falling confidence turned that hidden structure into an immediate test. Customers rushed to withdraw, and the CFTC complaint described an approximately $8 billion negative balance in the fiat at FTX account. A balance shown by the interface now had to become money leaving the institution. The run did not create the underlying custody problem. It exposed whether the promise could survive when many customers asked for their assets at once, and the internal balance had to be settled in the real world.
A fundamental challenge we face is that we're in many respects starting from near zero in terms of the corporate infrastructure and record keeping that one would expect in a multi-billion-dollar corporation.
This is the moment when the public message matters most. The filed complaint preserves Bankman-Fried's November 7th post. FTX is fine, and assets are fine. The significance is not the tone of a social media message by itself. It is that an assurance about solvency and assets reached customers during the exact period when withdrawal pressure was testing whether those words were true and whether delay would change customer decisions. Within days, reassurance gave way to bankruptcy. A contemporaneous PBS report described the sequence as questions about FTX, a rush by customers to withdraw, and then the bankruptcy filing. Another speaker in that report put the pressure plainly. Customers wanted the deposits they had placed with the exchange returned. The human consequence was not an abstract red number on a market chart. It was that a recorded customer claim could not be honored on ordinary demand by the institution that displayed it. After the bankruptcy, John J. Ray III took control of FTX and testified before the House. Ray described an unprecedented failure of corporate controls, concentrated in a small group of inexperienced people, using systems that did not fit a company holding other people's money. His point was larger than poor bookkeeping. The people responsible for safeguarding customer assets lacked the records, controls, and governance needed to show where those assets were, who could move them, and what limits actually applied. Then came the second reversal. Ray testified that senior management had access to systems that could redirect customer assets, and that Alameda could borrow funds held at FTX.com without effective limits. He continued through commingled assets, missing documentation, and the absence of audited or reliable financial statements. In another exchange, Ray reduced the obligation to ordinary words: keep records, maintain controls, and segregate other people's money. The failure behind the screen was therefore not just volatility, it was an institution that could not enforce, document, or reliably audit the boundary between a customer's asset and the affiliated firm's access.
They use QuickBooks, a multi-billion-dollar company using QuickBooks.
QuickBooks?
QuickBooks. Nothing against QuickBooks, very nice tool, just not for a multi-billion-dollar company.
The criminal case supplied a legal consequence distinct from the civil complaints and the bankruptcy process. A jury convicted Bankman-Fried on 7 counts of fraud and conspiracy. A federal judge sentenced him to 25 years in prison, a result carried in contemporary PBS reporting by a sentencing graphic and credited courtroom sketches. The conviction did not make every allegation in every regulator filing a criminal finding, but it resolved the core fraud case against him after a public trial. The current reason to revisit the case arrived on June 12, 2026. The Second Circuit's opinion identifies the appeal, summarizes the 7-count conviction, and ends with a single controlling disposition: affirm. That means the conviction and judgment remained in place after appellate review. It also makes the court's treatment of Bankman-Fried's repayment argument part of the ending, rather than an afterthought or a separate bankruptcy footnote. Bankman-Fried argued that he expected customers and investors to be made whole, but the appellate opinion rejected the idea that this erased the fraud.
That's the hope, and the bankruptcy lawyers have said they're expecting to make customers whole, but what being made whole means is complicated.
The court wrote that customers were defrauded when their money was transferred to Alameda without their authorization, even if repayment was later expected. It also explained that no customer had chosen to surrender control of money through false pretenses, even temporarily. Repayment can change the size of a financial loss and can matter greatly to a customer, but it does not retroactively create consent or remove the deception that caused the deprivation in the first place. That brings the film back to the promise made before the collapse. The Senate testimony said a platform should maintain enough liquid resources to return customer assets, custody them securely, and keep ledgers that prevent misuse. The CFTC complaint and Ray's testimony described the opposite boundary: special access, commingling, missing controls, and customer assets that could not be returned on demand. The durable warning is the distance between a balance displayed by software and custody that remains enforceable under pressure, with records and limits strong enough to survive the moment everyone asks at once. A later repayment may reduce harm, but it cannot turn money obtained through deception into permission that a customer freely gave when placing trust in the exchange.